citizens of the Philippines of Filipino mothers, those who born on January 17, 1973, of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. And number 4, those who are naturalized in accordance with the law. Citizenship. The definition: citizenship is personal in more or less permanent membership in a political community. It denotes possession within the particular political community of full civic and or of full civil and political rights subject to special disqualifications such as minority. Reciprocally, it imposes the duty of allegiance of the political community. Two ways of acquiring citizenship: by birth and by naturalization. Those ways of acquiring citizenship correspond to the two kinds of citizens: the natural born citizen and the natural citizens. A person who at the time at his birth is a citizen of a particular country is a natural born citizen thereof. As defined in the Constitution, natural-born citizens are those citizens of the Philippines from birth without having to perform any act to acquire or perfect his Philippine citizenship. On the other hand, naturalized citizens are those who have become Filipino citizens through naturalization, generally under Commonwealth Act 473, otherwise known as the Revised Naturalization Law, which repealed the former naturalization law in Act 2927 and by Republic Act number 530. So, jus sanguinis. Jus sanguinis or jus sanguinis or Jusanguinis. Jus sanguinis. Jus sanguinis. The Philippine law of citizenship adheres to principle of jus sanguinis. Thereunder, a child follows the nationality of or citizenship of the parents, regardless of the place of his or her birth, as opposed to the doctrine of jus soli, which determines nationality or citizenship on the basis of place of birth. Again, jus sanguinis. The Philippine law of or cities the Philippine law on citizenship adheres to principle sanguinis. Thereunder, a child follows nationality or citizenship of the parents, regardless of the place of his or her birth, as opposed to the doctrine of jus soli, which determines nationality or citizenship on the basis of the place of birth. The signing into law of the 1935 Philippine Constitution, the signing into law into 1935 Philippine Constitution, the signing into law into 1935 Philippine Constitution has established the principle of jus sanguinis as basis for the acquisition of the Philippine citizenship. So also, the principle of jus sanguinis, which confers citizenship by virtue of blood relationship, was subsequently written under the 1973 and 1987 Constitution. Thus, the herein private respondent Rosalyn Ibasco Lopez is a Filipino citizen, having been born to Filipino father. The fact of her being born in Australia is not tantamount to her losing her Philippine citizenship. If Australia follows the principle of jus soli, then at the most, private respondent can also claim Australian citizenship, resulting to her possession of dual citizenship. So section number 2, the natural-born citizens are those who are citizens of the Philippines from birth without having to perform any act of acquire or perfect their Philippine citizenship. Those who elect Philippine citizenship in accordance to paragraph 3, section 1 hereof shall be deemed natural-born citizens. Again, section number 2. Natural-born citizens are those who are citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. Those who elect Philippine citizenship in accordance with paragraph 3, section 1 hereof shall be deemed natural-born citizens. The non-commodity treatment. Philippine citizenship can never be treated like a commodity that can be claimed when needed and suppressed when convenient. One who is privileged to elect Philippine citizenship has only one inchoate right to such citizenship as such. He should avail of the right with fervor, enthusiasm, and promptitude. To be naturalized, an applicant has to prove that he possesses all the qualifications and none of the disqualifications provided by the law to become a Filipino citizen. The decision granting Philippine citizenship becomes executory only after 2 years from its promulgation when the court is satisfied that during the intervening period, the applicant has, number one, not left the Philippines, number two, has dedicated himself to a lawful calling or profession, number three, has not been convicted of any offense or violation of government promulgated rules, and number four, committed any act prejudicial to the interest of the nation or contrary to any government announces policies. The qualification that must be possessed by an applicant for naturalization in accordance with Section 2 of Act 473 are as follows. Letter A. Be not less than 21 years old on the day of the hearing of the petition. Letter B. He must be resided in the Philippines for a continuous period of not less than 10 years. Letter C. He must be a good moral character and believes in the principles underlying in the Philippine Constitution and must have conducted himself in a proper and irreproachable manner during the entire period of his residence in the Philippines and his relation with the constituted government as well as with the community in which he is living. Letter D, he must own real estate in the Philippines worth not less than 5,000 pesos, Philippine currency, or must have some non-lucrative trade, profession, or lawful occupation. Letter E, he must be able to speak and write English or Spanish and any principal languages, and he must have enrolled his minor children of school age in any of the public schools or private schools recognized by the Bureau of Private Schools of the Philippines, where Philippine history, government, and civic are taught or prescribed as part of the school curriculum during the entire period of the residence in the Philippines required of him prior to the hearing of his petition for naturalization as Philippine citizen. Section number 3. Philippine citizenship may be lost or reacquired in the manner provided by law. Again, Philippine citizenship may be lost or reacquired in the manner provided by the law. Philippine citizenship may be lost or reacquired provided by the law. Express renunciation. The express renunciation, in order that citizenship may be lost by renunciation, such renunciation must be expressed. The court ruled that the mere fact that he is an American did not mean that he is no longer a Filipino, and that an application for an alien certificate of registration was not tantamount to renunciation of his Philippine citizenship. Filipino citizens who have lost their citizenship may react the same in the manner provided by law. Commonwealth Act Number 63 enumerates the three modes of by which Philippine citizenship may be required by a former citizen, by naturalization, by repatriation, and by direct act of Congress. And section number 2, Act 473 provides the following qualification. Section number 2, Act 473 provides the following qualification. Section number 2, Act 473 provides the following qualification. Letter A, he must not be less than 21 years old of age on the day of the hearing petition. Letter B, he must reside in the Philippines for a continuous period of not less than 10 years. Letter C, he must be good moral character. He believes in the principles underlying the Philippine Constitution, must have conducted himself in a proper and irreproachable manner during the entire period of his residence in the Philippines and his relation with the constituted government as well as with the community in which he is living. Letter 3, he must own real estate in the Philippines worth not less than 5,000 pesos, Philippine currency, or must have known lucrative trade, profession, or lawful occupation. Letter E, he must be able to speak and write English or Spanish in any of the principal languages. And letter F, he must have enrolled his minor children of school age in any of the public schools or private schools recognized of private schools were prescribed as part of the school curriculum during the entire period of the residence of the Philippines, reacquired of him prior to the hearing of his petition for naturalization as Philippine citizen. In section number 4, Act 473 provides the following disqualification. In section number 4, Act 473 provides the disqualification of the following. Section number 4, Act 473 provide the disqualification of the followings. Number 1, he must not be opposed to organized government or affiliated with any association or group of persons who uphold and teach doctrines opposing all organized governments. Letter B, he must not be defending or teaching the necessity or priority of violence, personal assault, or assassination for the success and predominance of their ideas. Letter C, he He must not be a polygamist or believer in the practice of polygamy. Letter D, he must not have been convicted of any crime involving moral turpitude. Letter E, he must not be suffering from mental alienation or incurable contagious disease. Letter F, he must have during the period of his residence in the Philippines or not less than 6 months before the filing the application, mingled socially with the Filipinos or who have not events a sincere desire to learn and embrace the customs, traditions, and ideals of the Filipinos. Letter G, he must not be a citizen of or subject of a nation with whom the Philippines is at war during the period of such war. Letter H, he must not be a citizen or subject of a foreign country whose laws do not grant Filipinos the right to become naturalized citizens or subject thereof. Okay. Naturalization versus repatriation. Naturalization versus repatriation. Naturalization versus repatriation. Naturalization is a mode for both acquisition and reacquisition of Philippine citizenship. As a mode of initially acquiring Philippine citizenship, or reacquired in 1936. Under this law, a former Filipino citizen wishes to reacquire Philippine citizenship must pass a certain qualification, and none of the disqualification mentioned in section 4 of CA. On the other hand, may be had under various statutes by those who lost their citizenship due to desertion of the armed forces in section 4 CN, service in the armed forces of the Allied forces in World War II, service in the armed forces of the United States at the other time, marriage of a Filipino woman to an alien, and political and economic necessity. Repatriation, on the other hand, may had under various statutes by those who lost their citizenship due to desertion of the armed forces, service in the armed forces of the United States at any other time, marriage of Filipino woman to an alien, and political and economic necessity. As distinguished from the lengthy process of naturalization, repatriation simply consists of the taking of an oath of allegiance to the Republic of the Philippines and registering said oath in the local civil registry of the place where the person concerned resides or last resided. Moreover, repatriation results in the recovery of the original nationality. This means that a natural Filipino who lost his citizenship will be restored to his prior status as a natural Filipino citizen. On the other hand, if he was originally a natural-born citizen before he lost his Philippine citizenship, he will be restored to his former status as a natural. And section number 4. Section number 4, citizens of the Philippines who marry aliens shall return their citizenship unless by their act or omission they are deemed under the law to have renounced it. Under Commonwealth Act number 63, section 1, paragraph 7, a Filipino woman loses her Philippine citizenship upon her marriage to a foreigner if by virtue of the laws enforced in her husband's country she acquires his nationality. The 1973 Constitutional provision repeals this statutory rule, and the 1973 Constitution made it applicable not just to female citizens. Again, section number 4, citizens of the Philippines who marry aliens shall remain their citizenship unless by their act of or omission they are deemed under the law to have renounced it. Under the Commonwealth Act number 63, section 1, paragraph 7, a Filipino woman loses her Philippine citizenship upon her marriage to a foreigner if by virtue of the laws enforced in her husband's country she acquires his nationality. The 1973 constitutional provision repeals this statutory rule, and the 1973 Constitution made it applicable not just to female citizens. Section number 5. Dual allegiance of citizens is inimical to the national interest and shall be dealt with by law. Again, section number 5. allegiance of citizens is inimical to the national interest and shall be dealt by law. Section number 5, dual allegiance or of citizens is inimical to the national interest and shall be dealt with by a law. Dual citizenship versus dual allegiance. Dual citizenship arises when, as a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by the said states. For instance, such a situation may arise when a person whose parents are citizens of the state of jus soli. Such person, ipso facto and without facto on his part, is concurrently considered citizen of both states. Dual allegiance, on the other hand, refers to a situation in which a person simultaneously owes, by some positive act, royalty to two or more states, while dual citizenship is involuntary. Dual allegiance is the result of an individual's volition. Again, the dual citizenship versus dual allegiance. Dual citizenship arises when, a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by the said states. For instance, such a situation may arise when a person whose parents are citizens of the state which adheres to the principles of the jus sanguinis is born in state which follows the doctrine of jus soli. Such a person, ipso facto and without any voluntary act on his part, is concurrently considered a citizen of both states. Dual allegiance, on the other hand, refers to the situation in which a person simultaneously owes, by some positive act, loyalty to two or more states, while dual citizenship is involuntary. Dual allegiance is the result of individual's volition. Dual citizenship is involuntary. Dual allegiance is the result of individual's volition. And including section number 5 in Article 4 in citizenship, the concern of the Constitutional Commission was not with dual citizen per se, but with naturalized citizens who maintain their allegiance to their countries of origin even after their naturalization. Hence the phrase dual citizenship in RE number 7160, section 40, paragraph D, local government, consequently persons with mere dual citizenship do not fall under this disqualification. Under those with dual allegiance who must of candidacy, they elect Philippine citizenship to terminate their status as person with dual citizenship, considering that their condition is the unavoidable consequence of the conflicting laws of different states. So, by electing Philippine citizenship, such candidates at the same time forswear allegiance to the other country of which they are also citizens, and thereby terminate their status as dual citizens. It may be that from the point of view of the foreign state and of its laws, such an individual has not effectively renounced his foreign citizenship, that if no moment. Okay, let's proceed to article number 5. Article number 5, suffrage. Article number 5, suffrage. So section 1, suffrage may be exercised by all citizens of the Philippines, not otherwise disqualified by law, who are at least 18 years of age, have resided in the Philippines for at least 1 year, and in the place where for at least 6 months immediately preceding the election. No literacy, property, or other substantive requirement shall be imposed on the exercise of suffrage. Again, suffrage may be exercised by all citizens of the Philippines not otherwise disqualified by law, who are at least 18 years of age and who shall have resided in the Philippines for at least 1 year, and the place wherein they propose to vote for at least 6 months immediately preceding the election. No literacy, property, or other substantive requirement shall be imposed on the exercise of the suffrage. So suffrage, it is the right to vote in election. It was given the additional meaning of the obligation to vote. Suffrage is the right to vote in the elections. It was given the additional meaning of the obligation to vote. Who exercises. Suffrage may be exercised by all citizens of the Philippines not otherwise disqualified by law, who are at least 18 years of age and who shall have resided in the Philippines for at least 1 year, and in the place wherein they propose to vote for at least 6 months immediately preceding the election. So residence defined. The term residence as used in the election law is synonymous with domicile. which imports not only intention to reside in a fixed place, but also personal presence in the place, coupled with conduct indicative of such intentions. In order to acquire a domicile by choice, there must be concurrent residence or bodily presence in the new locality, an intention to remain there, and an intention to abandon the old domicile. In other words, there must be an animus non revertende and animus mandende. The purpose to remain in or at the domicile of choice must be for the indefinite period of time. The act person must conform with the purpose. The change of residence must be voluntary. The residence at the place chosen for the domicile must be actual, and so the fact of residence there must be added the animus mandende. More absence does not constitute abandonment. Mere absence from one's residence or origin, domicile to pursue studies, engage in business or practice his vocation is not sufficient to constitute abandonment or loss such residence. A citizen may leave the place of his birth to look for greener pastures to improve his lot. When election is to be held, the citizens who left his birthplace to improve his lot may desire to return to his native town to cast his ballot, but for professional or business reason, he may not be absent himself from the place of his activities. So there registered his domicile or residence of origin, he has not forsaken him. Thus, registration of a voter in another place has not been deemed sufficient to constitute abandonment or loss of such residence. And Section 2, the Congress shall provide a system for securing the secrecy and sanctity of the ballot as well as a system for absentee voting by disqualified Filipinos abroad. Again, Section number 2, the Congress shall provide a system for securing the secrecy and sanctity of the ballot as well as a system for absentee voting by the qualified Filipino abroad. Again, Section number 2, the Congress shall provide a system for securing the secrecy and sanctity of the ballot as well as system for absentee by voting of Again, Section number 2, the Congress shall provide a system for securing the secrecy and sanctity of the ballot as well as a system for absentee voting by qualified Filipinos abroad. The Congress shall also design a procedure for the disabled and the illiterates to vote without the assistance of other persons, and then they shall be allowed to vote under existing laws in such rules as the Commission on Election may promulgate to protect the secrecy of the ballot. Exhaustive discussions on these provisions are found in the electoral law course. To Article number 6, the Legislative. The Legislative, Section number 1. Legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved by the provision on initiative and referendum. Again, the legislative power shall be vested in the Congress of the Philippines, which shall consist the Senate and the House of Representatives, except to extent reserved to the people by the provision on initiative and referendum. The legislative department, the legislative power shall be vested in the Congress of the Philippines, which shall consist in the House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. Who exercises legislative power? The power may exercises legislative power Congress, local government units, and the people through initiative and referendum. The limitation legislative power of Congress. The Constitution itself provides limitations on the exercise of legislative powers, substantive limitations on the content of laws, procedural limitations on the manner of passing the laws. Congress cannot pass irrepealable laws and, as a general rule, cannot delegate its legislative power. So, powers of Congress. The legislative power. The power or competence to propose, enact, ordain, amend, alter, modify, abrogate, or repeal laws. It is vested in the Congress, which shall consist of a Senate and the House of Representatives, extent reserved to the people by the provision on initiative and referendum. The legislative power, the power of competence to propose, enact, ordain, amend, alter, modify, abrogate, or repeal laws, it is vested in the Congress, shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision of on initiative and referendum. Legislative powers of Congress, general plenary power, specific power of appropriation, taxation and expropriation, legislative investigation in question hour, doctrine of shifting majority for each House of Congress to pass votes of the majority of the present in the session is required. The limitations on legislative powers. Substantive limitation expressly provided in the Constitution are Bill of Rights on appropriation, on taxation, on constitutional appellate jurisdiction, no law granting a title of royalty or nobility shall be enacted, no specific fund shall be appropriated or paid for use or benefit of any religion, section, etc., except for press, etc., assigned to EFP, penal institution, etc. Impliedly provided prohibition against irreparable loss and non-delegation of powers, exceptions to the non-delegation doctrine, delegation to the president, and delegation to the people. Procedural limitation. The procedural limitations provided by the Constitution on the legislative power are as follows. 1. Subject to be stated in the title of the bill. 3. Readings on the separatist printed copies of the bill in its final form to be distributed to its members 3 days before its passage, except if the President certifies to its immediate enactment to meet a public calamity or emergency. Be allowed and vote thereon should be taken immediately, and the use needs either into the journal. Appropriation bills, revenue bills, tariff bills, bills authorizing and increase of public debt, bills of process of legislative power, original, which is possessed by the people of their incapacity. Bodies by Constitution, constituent the power to amend or revise the Constitution and ordinary the power to pass ordinary laws. In section number 2, the Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines as may be provided by the law. Again, section number 2, the Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines as it may be provided by the law. Section number 3, no person shall be senator unless he is a natural born citizen of the Philippines and on the day of the election is at least 35 years of age, able to read and write, a registered voter in the resident of the Philippines for not less than 2 years immediately preceding the day of the election. Again, section number 3, no person shall be a senator unless he is a natural born citizen of the Philippines and on the day of election is at least 35 years of age, able to read and write, a registered voter and a president of the Philippines for not less than 2 years immediately preceding the day of the election. Section number 4, the term of the office of the senator shall be 6 years and shall commence unless otherwise provided by law at noon on the 13th day of June next following their election. No senator shall be served for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term of which he was elected. The term of the section number 4, the term of the office of senators shall be 6 years and shall commence unless otherwise provided by law at noon on the 13th day of June next following their election. No senator shall serve for more than 2 No senator shall be served for more than 2 consecutive years or terms. Voluntary renunciation of office for any length of time shall not consider as an interruption in the continuity of his service for the full term of which he was elected. Section number 5. Shall be composed of not more than 250 members unless otherwise fixed by law, who shall be elected from legislative districts, a portion among the provinces, cities, and the metropolitan Manila area in accordance with the number of their respective inhabitants and on the basis of the uniform and progressive ratio, and those who, as provided by law, shall be elected through a party-list system or registered national, regional, and sectoral parties or organizations. Number 2, the party-list representatives shall constitute 20% of the total number of the representatives, including those on the party list for 3 consecutive terms. The ratification of this constitution, one half of the seats allocated to party list representatives shall be filled as provided by law by selection on or election from the labor, peasant, urban, poor, indigenous, cultural, communities, women, youth, and such other sectors as may be provided by law except the religious sector. Again, the party list representatives shall constitute 20% of the total number of representatives, including those under the party list, for 3 consecutive terms after those under the party list for 3 consecutive terms after the ratification of this constitution. One half of the seats allocated to party list representatives shall be filled as provided by law by selection or election from the labor, peasant, urban, poor, indigenous, cultural communities, women, youth, in such other sectors as may be provided by law except the religious sector. Party list representatives. Party list representatives. The House of Representatives shall constitute 20% of the total amount of representatives elected through a party list of the registered national, regional, and sectoral parties or organizations. The party list system is not synonymous with sectoral representation. Prevailing guidelines in the party list representation. Number 1, 3 different parties or organizations may participate in the party list system. Letter A, national. Letter B, regional. Letter C, sectoral. Again, prevailing guidelines in party list representation. There are 3 parties of organization may participate in the party list system: the national, the regional, and the sectoral. Number 2, national and regional parties of organizations do not need to, letter A, organize along sector lines. Letter B, represent any marginalized or underrepresented sector. Number 3, political parties may participate in the party list system provided. Letter A, again, number 3, political parties may participate in the party list system provided. Letter A, they register under the party list system. Letter B, they do not field candidates in legislative district elections. Letter A, party that participates in the legislative districts election may still participate in the party list through a sectoral wing. The sectoral wing can be part of the political party's coalition, but the former must be registered independently in the party list system. Number 4, sectoral parties or organization may either A, marginalized or underrepresented. Letter B, lacking on well-defined political constituents, women, elderly, youth. The nominees of sectoral parties or organization of either type must belong to their respective sectors, have a track record of advocacy for their respective sectors. Majority of the members of the sectoral party of either type must belong to the sector they represent. The national, regional, or sectoral parties of organization shall not be disqualified if some of their nominees are disqualified, provided that they have at least one nominee who remains qualified. So the disqualified parties: number 1, the religious sectors; number 2, the foreign organizations; number 3, the advocating violence or unlawful means; number 4, receiving support from any foreign government, foreign political party, foundation, organization, whether directly or through any of its officers or members, or indirectly through third parties for partisan election purposes. Number 5, violates or fails to comply with laws, rules, or regulations relating to the elections. Number 6, declares untruthful statements and expectation. Number 7, cease to exist for at 1 year, or it fails to participate in the last 2 preceding elections, or fails to obtain at least 2% of the votes cast under the party list system in the 2 preceding elections for the constituency in which it has registered. The qualified sectors, this qualification applies only to sectoral parties. Participating national or regional parties did not fall under any of these sectors. Number one, labor, to peasant, fisherfolk, urban poor, indigenous cultural communities, elderly, handicapped women, youth, veterans, overseas workers, professionals. The four parameters of the party list system: 20% 20% of the total number of the membership of the House of Representatives is the maximum number of seats available to party list organization. 2% threshold garnering 2% of the total vote cast in the party guarantees a party list organization one seat. 3 additional seats, that is the remaining seats after allocation of the guaranteed seats, shall be distributed to the party list organization, including those that receive less than 2% of the total votes. The district Each legislative district shall comprise, as far as practicable, contiguous compacts territory is city with a population of at least 250,000, or each province shall have at least one representative. Within 3 years following the return of every census, the Congress shall make apportionment or legislative districts based on the standards provided in this section. The district representatives, those who are elected from the legislative districts, apportion among the provinces, cities, and the metropolitan Manila area. Apportionment of legislative districts. The legislative districts are apportioned among the provinces, cities, and the metropolitan Manila area. They are apportioned in accordance with the number of the representative, or the numbers of the respective inhabitants, and on the basis of a uniform and progressive ratio. The apportionment is the determination of the number of representatives which a state, country, or other subdivision may send to a legislative body. It is the allocation of seats in a legislative body in proportion to the population, drawing of the voting district lines so as to equalize population and voting power. Each city with a population of at least 250,000 shall have at least one representative. Each province, irrespective of the number of the inhabitants, shall have at least one representative. While Section 5, Paragraph 3 of Article 6 requires a city to have a minimum population of 250,000 to be entitled to one representative, it does not have to increase its population by another 250,000 to be entitled to one additional district. Okay. When census not needed, when one of the municipalities of a congressional district is converted to a city large enough to entitle to one legislative district, the incidental effect is the splitting of the district into two. The incidental arising of a new district, and this manner need not to be preceded by a census. The essence of the apportionment, the underlying principle behind the rule for apportionment, is the concept of equality of representation, which is a basic principle of much weight as the vote of every other apportionment law is justifiable question. Conditions for appointment. The following are the conditions for appointment. Number 1, elected from legislative districts which are apportioned in accordance with the number of inhabitants of each area and based on uniform and progressive ratio. Number 2, uniform. Every representative of Congress shall present a territorial unit with more or less a population of 250,000. All the other representatives shall have the same or nearly the same political constituency, so much so that their votes will constitute the popular majority. Progressive, it must respond to the change in times. The number of the House of Representatives must not be so big as to the unwieldy. From 250,000 constituents, one representative, it may reapportion to 300,000 constituents and one representative. Number 4, each city with a population of at least 250,000 or each province, irrespective of number of inhabitants, shall at least have one representative. Generally, there must be proportional representation according to the number of their constituents, inhabitants, except in one city, one representative, one province, one representative rule. Number 5, legislative districts shall be reapportioned by Congress within 3 years after the return of his census. The manner of reappointment. Reappointment is the realignment or change in legislative districts brought about by change in legislative districts brought about by changes in the population and mandated by the constitutional requirement of equality of representation. The reappointment may be made through a special law. The Constitution did not preclude Congress from increasing the membership of by passing a law other than a general reappointment of the law to hold the reappointment can only be made through a general apportionment law with a review of all the legislation districts allocated to each local government unit nationwide would create an equitable situation where a new city or province created by Congress will be denied legislative representation for an intermediate indeterminate period of time. Thus, a law converting a municipality into a highly organized city automatically creates a new legislative district and consequently increase in the membership. Okay. No plebiscite needed for a new district. The Constitution that Again, no plebiscite needed for a new district. The Constitution does not require does not require a plebiscite for the creation of new legislative district by a legislative reappointment. It is required only for the creation of the new local government units. In section 6, section number 6, person shall be a member of the House of Representatives unless he is a natural born citizen of the Philippines and on the day of the election is at least 25 years of age, able to read and write and accept the party-list representatives, a registered voter in the district in which he shall be elected and a resident thereof for a period of not less than 1 year immediately preceding the day of election. Again, section number 6, no person shall be a member of the House of Representatives unless he is a natural born citizen of the Philippines and on the day of the election is at least 25 years of age, able to read and write and accept the party list representatives, a registered voter in the district in which he shall be elected and resident thereof for a period of not less than 1 year immediately preceding the day of the election. The minimum requirement under our Constitution and election laws for the candidates' residency in the political unit they seek to represent has never been intended to be an empty formalistic condition. It carries with it a very specific purpose to prevent strangers or newcomers unacquainted with the conditions and needs of a community from seeking elective offices in that community. The law does not require a person to be in his home 24 hours a day and 7 days a week to fulfill the residency requirement. The retaining domicile of origin gaining a new home. The retaining domicile of origin gaining a new home. The retaining domicile of origin gaining a new home. The court upheld the qualification of Mrs. Imelda Romualdez Marcos despite her own declaration in her certificate of candidacy that she had resided in the district for only 7 months because of the following. A minor follows the domicile of his parents, Tacloban, become Imelda's domicile of origin by operation of law when her father brought the family to Leyte. B. Domicile of origin is lost only when there is an actual removal or change of domicile, a bona fide intention of abandoning the former residence and establishing a new one, and acts which correspond with the purpose in the absence of clear and positive proof of the concurrence of all this, the domicile of origin should be deemed to continue. The wife does not automatically gain the husband's domicile because the term residence in civil law does not mean the same thing in political law. When Imelda married Marcos in 1954, she kept her domicile of origin and merely gained a new home with a domicilium necessarium. Even assuming that she gained a new domicile, after the marriage and acquired the right to choose a new one, and only one after her husband died. Her acts following her return to the country clearly indicate that she chose Tacloban, her domicile of origin, as her domicile of choice. Again, the retaining domicile the retaining domicile of origin gaining a new home. The court upheld the qualification of Mrs. Imelda Romualdez Marcos despite her own declaration of her certificate of candidacy that she had resided in the district for only 7 months because of the following. A minor follows of the domicile of his parents, Tacloban became Imelda's domicile of origin by operation of law when her father brought the family to Leyte. Domicile of origin is lost only when there is an actual removal or change of domicile, a bona fide intention of the abandoning the former residence and establishing a new one, and acts which correspond with the purpose in the absence of the clear and positive proof of the concurrence of all this, the domicile of origin should be deemed to continue. The wife does not automatically gain the husband's domicile because the term residence in civil law does not mean the same thing in political law. When Imelda Marcos in 1954, she kept her domicile origin and merely gained a new home with a domicilium necessarium, even assuming that she gained a new domicile after her marriage and acquired the right to choose a new one only after her husband died. Her acts following her return to country clearly indicate that she chose Tacloban, her domicile of origin, as her domicile of choice. The transfer of domicile, not supported by facts of the case, Agapito Aquino failed to prove that he had established not just residence but domicile of choice in Makati, and his certificate of candidacy for the 1992 elections. He indicated that he was resident of San Jose Concepcion, Tarlac for 52 years. He was a registered voter of the same district. His birth certificate places Concepcion in Tarlac as birthplace. Thus, his domicile of origin was Concepcion, Tarlac, and his bare assertion of transfer of domicile from Tarlac to Makati to hardly supported by the facts of the case. The domicile of origin is lost when one becomes a citizen of the foreign country. The domicile of origin is lost when one becomes a citizen of the foreign country. So petitioner had not been a resident of Oras Eastern Samar for at least 1 year prior to May 14, 2001 elections. Although Oras was his domicile of origin, petitioner lost the same when he became a U.S. citizen. After enlisting the U.S. Navy from then on until November 10, 2000, when he required Philippine citizenship through repatriation, petitioner was an alien without any right to reside in the Philippines. Immigration to the U.S. by virtue of the acquisition of a green card constitutes abandonment of the domicile in the Philippines. Section number 7. The members of the House of Representatives shall be elected for the term of 3 which shall begin unless otherwise provided by the law at noon at the 13th of June next following their election. No member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for full term for which he was elected. Okay. Section number 8. Unless otherwise provided by law, the regular election of the senators and the members of the House of Representatives shall be held on the second Monday of May. Section number 9. In case of vacancy in the Senate or in the House of Representatives, a special election may be called to fill such vacancy in the manner prescribed by law, but the senator or member of the House of Representatives, those elected, shall serve only for the unexpired terms. Section number 10. Salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full compensation shall take effect until after the expiration of the full term of the of all members of the Senate and the House of Representatives approving such increase. Section 11. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress in the session. No member shall be questioned, nor be held liable in any other place for any speech or debate in the Congress or in the committee thereof. The purpose of immunity, it is for the benefit of the officials rather if is protect and support the rights of the people by ensuring that their representatives are doing their jobs according to the dictates of their conscience and to ensure the attendance of the congressman. Coverage of speech. Purpose of immunity. It is for the benefit of the officials, rather it is to protect and support the rights of the people by ensuring that the representatives are doing their jobs according to the dictates of their conscience and to ensure the attendance of congressmen. The coverage of speech or debate. It includes utterances made by congressmen in the performance of their official functions such as speeches, delivered statement made of votes cast in the halls of Congress, whether the same as in session or not, and the other acts performed, housing its offices, and the official discharge of their duties as members of the Congress and act congressional committees duly authorized to perform its function as such at the time of the performance of the acts in question. The purpose of legislative privilege. The purpose of the privilege is to ensure the effective discharge of functions of Congress. The privilege may be abused, but it is said that such is not damaging or detrimental compared to the denial of withdrawal of such privilege. Ako na naman sa judicial. Nantay sa judicial. Okay, the Executive Department. Section number 1. The executive power shall be vested in the President of the Philippines. The Executive Department. The executive power shall be vested in the President of the Philippines. So, non-encroachment of judicial power, the government through the PCGG in binding itself to cause the dismissal of all cases against the Marcos heirs pending before the Sandigan Bayan in other courts in the comprehensive agreement is a direct encroachment on judicial power, particularly in regard to criminal jurisdiction. Well settled is the doctrine that when a case has been filed before a court of competent jurisdiction, the matter of its dismissal or pursuance lies within the full discretion and control of the judge. In a criminal case, the manner in which the prosecution is handled, including the matter of whom to present as witnesses, may lie within the sound discretion of the government prosecutor, but the court decides based on the evidence proffered in what manner it will dispose of the case. Jurisdiction, once acquired by the trial court, is not lost despite a resolution, even by the Justice Secretary, to withdraw the information or to dismiss the complaint. The prosecution's motion to withdraw or to dismiss is not the less binding upon the court. On the contrary, decisional rules require the trial court to make its own evaluation of the merits of the case, because granting such motion is equivalent to effecting the disposition of the case itself. Thus, PCGG as the government prosecutor of ill-gotten wealth cases cannot guarantee the dismissal of all such criminal cases against the Marcoses pending in the courts, for said dismissal is not within its sole power and discretion. The President's Act of delegating authority to the Secretary of Justice by virtue of Memorandum Circular Number 58 is well within the purview of the doctrine of qualified political agency. The President did not proclaim a national emergency, only a state of emergency. The calling out of the armed forces to prevent or suppress lawless violence in such places is a power that the Constitution directly vests in the President, without need of congressional authority to exercise the same. The abolition of the PAGC or PAGC and the transfer of its function to a division specially created within the ODESLA is to properly within the prerogative of the President under his continuing delegated legislative authority to reorganize his own office pursuant to Executive Order number 292. Directives in orders issued by the President and the valid exercise of his power of control over the executive department must be obeyed and implemented in good faith by all executive officials. Acts performed in contravention of such directives merit invalidation. The President's discretion in the conferment of the Order of the National Artist should be exercised in accordance with the duty to faithfully execute the relevant laws. The faithful execution clause is the best construed as an obligation imposed on the President's not separate grant of power. It simply underscores the rule of law and corollary the cardinal principle that the President is not above the laws, but it is obliged to obey and execute them. This is precisely why the law provides that administrative or executive acts, order, and regulations shall be valid only when they are not contrary to the laws or the Constitution. It is apparent from the foregoing constitutional provisions that the only instances in which President may not extend pardon to be in number one, impeachment cases, number two, cases that have not yet resulted in a final conviction, and number three, cases involving violations of elections laws, rules, and regulations, in which recommendation coming from. Therefore, it can be argued that any act of the Congress by way of statute cannot operate to delimit the pardoning power of the President. The Qualified Political Agency Doctrine. The doctrine of qualified political agency declares that, save in matters on which the Constitution or the circumstances require the President to act personally, executive and administrative functions are exercised through executive departments headed by cabinet secretaries, whose acts are presumptively the acts of the President and is disapproved by the latter. There can be no question that the act of the Secretary contracts entered into by toll board. Section number 2. No person may be elected president unless he is a natural born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age, qualifications in term of the office, and be elected with, and in the same manner as the president, he may be removed from elected. But in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress voting separately. The Congress shall promulgate its rules for the banking of the court sitting in bank sole judge of all the contests relating to the election, returns, and qualification of the president or vice president, and may promulgate its rules for the purpose. Again, the Supreme Court, sitting in bank, shall be sole judge of all contests relating to the election, returns, and qualifications of the president or vice president, and may promulgate its rules for the purpose. Valid congressional delegation. Congress may valid case of canvassing the presidential and vice presidential election results without need of any call for a special session by the president. Only when the board of canvassers has completed its function, it rendered functions. Section